So looking for dates, Madam Speaker, of course, the first one is actually already passed. It's January of 2023, and that's when retroactively actions are eligible for getting credit after the credit system is established if work is done. If that system isn't established for a couple of years, I guess that's a couple of years worth of people not knowing exactly what they have to keep track of, but keep track of everything so that they can claim that credit. The next time point is at enactment, of course. And not everything happens at enactment, but at enactment, a number of things go into play. Obviously, the funding in this year's budget, all of the positions and the consultant positions are all part of the enactment. But I think the starting question is what exactly is it that we are enacting? There's been a lot of conversation or statements that make it similar to a study or talk about, well, we're gathering all the information for a later decision in 2025. And I think the language of the bill makes it pretty clear that that's not what we're doing. That is certainly what we should have been doing and could have been doing, is actually setting this up and saying, we are going to gather all this information in order to then make an informed decision. But what we're doing with this bill, if we look to page 1885, the very section 8122, Clean Heat Standard, really basic, straightforward first sentence. The Clean Heat Standard is established, period. It's not will be established based on what we learn over the next 2 years. Under this program, obligated parties shall reduce greenhouse gas emissions attributable to the thermal sector by retiring required amounts of clean heat credits. It's what we are enacting. The second part of that, by rule or order, the Commission will establish or adopt a system of tradable clean heat credits earned from the delivery of clean heat measures. It's not, we'll look into what it would take. It's not study what the elements would be. It is, shall establish or adopt by enactment of this bill. C, under that initial enactment, an obligated party shall obtain the required amount of clean heat credits through delivery of eligible clean heat measures by a default delivery agent. Not find out what that would take, not study it, not bring information back to a future legislature, shall do it. And finally, the Commission shall adopt rules and may issue orders to implement and enforce. That authority, implement and enforce, is what we are enacting with this bill. So to not enact this, to not be established, would mean needing to repeal what we pass. The General Assembly can refuse to approve the rules that are drafted in 2025, but that does not repeal this act and the enactments that we are proposing in this bill. That would require repeal. And in fact, if we look further at what we're doing and what can or can't happen with or without the General Assembly, we need only to turn to yesterday's calendar again, 1894, where it's very explicit that the requirements to adopt rules and any requirements regarding the need for legislative approval before any part of the Clean Heat Standard goes into effect. So any requirements regarding legislative approval for any part going into effect do not in any way impair the Commission's authority to issue orders or take any other actions, both before and after final rules take effect, to implement and enforce the Clean Heat Standard. That's really explicit. So no matter. It's interesting that in addition, the committee's rules can themselves put a provision in that say we can revise our rules by order without having to follow the Administrative Procedures Act. So it's a pretty broad spread of authority. And in terms of what we're enacting, it's also clear that those heat credits on that the annual requirements shall be set at a pace sufficient for Vermont's thermal sector to achieve the reductions required under the Global Warming Solution Act. And the Commission also has enforcement authorities for all of this on page 1890. The committee shall have the authority to enforce the requirements of this chapter and any rules or orders adopted to implement the provisions of this chapter. This is not fact-finding. This is orders of implementation. It's requirements of steps and aspects which can occur notwithstanding anything that says the legislature can approve or disapprove the rules. That's on enactment. Starting July 1st, around the time of enactment this year, the Commission opens proceedings to establish the credit costs. That's not opening proceedings to review or develop information or gather information or study. It is opening a procedure to establish the default delivery agent credit costs or costs. And those procedures then also include a potential study. And Madam Speaker, I must say, I read this a couple times before I realized that that meant a study on potentiality as opposed to we potentially might or might not do a study, because it's not quite the jargon I'm used to in terms of this area of law. But so this study is actually gathering a couple of specific things. It's an assessment and quantification of technically available, maximum achievable, and program achievable thermal resources. And it also considers and evaluates market conditions for delivery of measures, in other words, whether it can be done, and workforce characteristics. These are exactly the pieces of information we need in order to pass this bill to establish the standard. These are the things that we should be gathering before passing a bill that says we are creating this and we are implementing it. In this July 1st timeframe start point, we also create the Technical Advisory Committee. Somewhat unusual construct from what I'm used to, because it's the commission itself that creates it and also appoints all the members. And likewise with the Equity Advisory Committee. It creates it and it appoints all the membership. There's no outside participation by other groups nominating or proposing membership. And finally, it also designates the hiring of the consultant. So that's all starting July 1st, all those aspects. By or before August 31st is when the rulemaking begins the rulemaking to implement. Again, not a process to gather information. It's rulemaking designed to create the entire implementation structure. It's intentionality about implement. It's not intentionality about drafting a plan. We have a somewhat unique aspect where this rulemaking process that begins is constructed in its own way, separate from the standard rulemaking process. It actually allows narrower input because it lists out the areas for public engagement rather than allowing the public to provide any input it pleases. It's actually going to be facilitated for specific purposes, but also of particular interest. At the bottom of page 1903, subpart C, Any failure by the Commission to meet the specific procedural requirements for public input, in other words, shall not affect the validity of the Commission's actions. So that's all what goes into effect this year. January 31st is when the sellers of heat sources must register. So that's interesting because this is something that we're still supposedly only studying, but actually implementing. Each entity that sells heating fuel into or in Vermont shall register. First registration deadline, January 31st of next year, 2024. So we are registering every entity that sells next January. This is not a study. This is not a gathering of information to make decisions in 2 years. This is implementation. The sellers have to register next January. And then in February, legislative update gives us the first two major things that we ought to have before passing a bill that creates this standard, which we specifically identify what the suggested revenue streams might be. Interesting, because usually before we pass a bill, we identify the revenue streams. And then under I, estimates of the impact on customers, impacts on customer rates, potential impacts on fuel bills for participating and non-participating customers, net impacts on total spending for energy on the thermal sector, and if possible, impacts on economic activity and employment. Those are the pieces of information that we should have before we make a decision to commit to this entire program and project in the way that we commit and establish this standard in this bill voting today. In June of 2024, still before legislature approving just the rulemaking process, we actually have the appointment of the designated agents for up to a 12-year contract. Signing a 12-year contract 6-7 months before the date that the legislature would review rules and decide to approve the rulemaking portion or not. So, Madam Speaker, I think it's really important to understand that when we get to January of 2025, it will not be the time to readjust. It will not be the time to assemble all the information that was gathered and enter into a decision-making process. All that information was acted upon in establishing the program. There's just a thumbs up or thumbs down on the rules of implementation. We don't even know what might be established by order in the interim, because they can implement by order, not just by rules. This is not a study. It's not just information gathering. It's enacting in statute the Clean Heat Standard and all of the components of it. Those are all shalls. They're not may. They're not evaluate. Madam Speaker, I think we need to continue to be active and aggressive in taking our responsibility to address climate change, but our part will not change the world trajectory. What this bill does is place the cost of attempting to change the world trajectory on our small population, with a highly disproportionate impact on our constituents and our entire state economy, without even having a fundamental grasp of how high those costs may be. I cannot support this bill as presented today.